Hello, everyone. My name is Jack Tuter, and I'm the Chief Judge in the 17th Judicial Circuit, which serves Broward County. Today, I'd like to give you a brief overview of risk protection orders in Florida. As a result of the shooting at Marjory Stoneman Douglas High School, the 2018 Florida Legislature enacted a risk protection order statute. The statute permits a law enforcement officer or agency to petition a circuit court judge for a risk protection order. The petition must allege that a person who is called the respondent poses a significant danger to himself, herself, or others. In cases where it's alleged that physical harm may occur in the near future, the judge has to hold a hearing to determine if reasonable cause exists to enter a temporary risk protection order. The hearing has to be held with the petitioning police officer or agency within 24 hours after the petition is filed. If the judge enters the risk protection order, the order and petition are served on the respondent by a law enforcement agency, and the respondent is required to surrender to law enforcement any weapons, ammunition, or concealed weapon permits in his possession. The judge's temporary risk protection order sets a date for a final hearing, which must be held within 14 days after the temporary order is entered. Until the final hearing is held, the respondent is prohibited from owning, possessing, or attempting to own or possess a firearm or ammunition. At the final hearing, the petitioning law enforcement agency must prove by clear and convincing evidence that the respondent poses a significant danger of causing personal injury to himself or others by possessing a firearm or ammunition. Both sides can present evidence as in any other trial. If proven, the judge can enter the risk protection order for up to 12 months. The order prohibits the respondent from owning or possessing or attempting to own or possess any firearm or ammunition. If the judge issues a risk protection order, the judge must inform the respondent that he or she is entitled to request a hearing to vacate the order. All risk protection orders are reported to the National Crime Information Center and stay in that database for as long as the order is in place. There are both criminal and civil penalties for non-compliance with a risk protection order. Those penalties include charging a person who has a firearm while the subject of a risk protection order with a third-degree felony, punishable by up to 5 years in prison. If the petition for a final risk protection order is denied, any weapons or ammunition which may have been seized must be returned to the respondent. Risk protection orders are particularly tricky with juveniles. There is no provision in the statute to appoint an attorney, as these are considered civil proceedings. Further, many jurisdictions in Florida reveal the name of the juvenile in the risk protection pleadings and do not afford protections that he or she may be entitled to in the juvenile court. The petitions that I have seen have a common thread, which is the respondent has threatened himself or others, or has committed an act of violence against another and continues to pose a threat. In my opinion, after 12 months of enactment of the statute, it seems to be effectively carrying out its purpose, which is to identify persons who have demonstrated a significant risk of harming themselves or others and prevent them from obtaining a weapon or ammunition.